the courts are going in the opposite direction. And the court began to reconsider its approach to economic liberty. But the court maintained a space for personal liberty cases. Okay? All right, so today we have three very, very, very important cases to study. Okay? We have West Coast Hotel v. Parrish. We have United States versus Carolene Products. And we have Williamson versus Lee Optical. These three cases revolutionize how the Supreme Court handles constitutional law. Right? Completely revolutionize how the Supreme Court handles constitutional law. Right? Let's give some background first. Right? Throughout the 1920s, the Supreme Court was fairly robust in reviewing claims of economic liberty. And this was not only done through the Commerce Clause, it was not only done through the 14th Amendment Due Process Clause, but in the first half of the class, we talked about Commerce Clause. And you had many cases where the Supreme Court declared unconstitutional federal regulations. Think of Schechter Poultry, right? Which was the sick chicken case, right? Think of Hammer versus Dagenhart, which was about the child labor case. Throughout the 1920s and to the 30s, the Supreme Court was more willing to declare unconstitutional federal labor laws. And they said that these federal laws went beyond Congress's powers. We did this the first half of the semester. Okay? But also during the second half, during the 20s and 30s, the court started to review state laws more skeptically. So you have Lochner, you have Buchanan, you have Meyer, you have Pierce, and you have Atkins, which was kind of a federal case, but not really. And these cases relied on the Due Process Clause. So during the so-called Lochner era, the court used both the Commerce Clause doctrine and the Due Process Clause doctrine to scale back federal and state progressive laws. This approach proved to be very controversial. Right? This approach proved to be very controversial. Progressives were being elected in large numbers in state and federal governments, and they wanted to use their newfound power to enact legislation to change social circumstances. And it seemed that the only thing stopping the courts, the only thing stopping those movements was the courts. And the courts were more conservative than society at large, which is often the case. This issue came to a head after President Roosevelt was elected in 1932. This is very famous history. I'm not giving anything that's novel, right? And between 1932 and 1937, during Roosevelt's first term, the Supreme Court declared a lot of his actions unlawful. Right? You had Schechter Poultry. Right? You had a couple other cases I haven't assigned where the court said that Roosevelt had gone too far. And during the same time, you had state laws being declared unconstitutional. Now, it wasn't all of them. There were laws that were upheld, but there were a sizable number of laws that were held invalid. right? This is the so-called Lochner era. Even though the case had nothing to do with Lochner. Lochner was at the bakeries. It's fairly minor stuff, but the phrase Lochner caught on, and that's what this era was referred to as. Okay? Then we get to the case of West Coast Hotel v. Parrish. This was a challenge to a Washington state minimum wage law for women. Okay? So, Clay, you here?
Yes, sir.
All right, Clay, thank you. Clay, what was the holding in Atkins? Atkins v. Children's Hospital. What was the holding in that case?
Give me 1 second. So this is the fixing minimum wages for women and children, and so this case is kind of along the same lines, and this was regulating the minimum wage for.
Well, let me just stop you there, right? So Atkins held that you cannot impose a minimum wage just for women, right?
Yes.
What did Washington State do?
Attempted to regulate the minimum wage paid to women.
Wait a minute. I thought you just said a minute ago that the Supreme Court held you can't do that.
They change their mind sometimes.
Had they changed their mind when Washington enacted this law?
Yes, they said that they could.
No, but that case came after Washington enacted the law. My question is different. When Washington enacted the law, was Atkins still good law?
Yes.
So, Clay, help me out here. How can the Washington government enact a statute that is in direct violation of a Supreme Court precedent?
I assume that they're attempting to change it, knowing that the court makeup has changed.
Can you do that? Can you enact a law that goes against Supreme Court precedent? Are you allowed to do that?
I don't. They're not really supposed to, but it looks like they tried.
Yeah, they tried. Yeah, thanks, Clay. So this is sort of a weird case, right? Where the Washington government did exactly what the government said you cannot do. Right? The court says you can't have a minimum wage, and they did it anyway. I think this history shows that there was a growing, hostility towards the court. There was hostility that the court was getting in the way of progressive legislation. And the court was the people were simply not interested in dealing with the court. Now, maybe this was a test case. I think it's more they just didn't care. They thought this was important, the minimum wage was important, they're going to do it. So Washington enacts the minimum wage, and you have Elsie Parrish, who was a chambermaid at the West Coast Hotel in Wenatchee, Washington. It's actually, not funny is the wrong word, but the case isn't actually brought by her, because at the time women couldn't sue on their own behalf. The case was actually brought by her husband, who brought the suit on behalf of his wife. And the husband brought the lawsuit, challenging the hotel's refusal to pay her minimum wage. All right, you're with me so far. All right, so a few things to keep in mind here. The Supreme Court had upheld in Atkins the minimum wage for women in 1926, about a decade earlier. The court had also upheld a minimum wage in New York in a case called Tipaldo, Tipaldo, Tipaldo. And the vote in Tipaldo was 5-4. 5-4. In Tipaldo, the parties did not ask the court to overrule West Coast Hotel. Did not ask the court to overrule Atkins. But in West Coast Hotel, Parrish expressly asked the court to overrule Atkins. Right? All right, so here comes the timing. The timing of this case proves to be very important. In early 1937, President Roosevelt announces what came to be known as a court packing plan. Okay, it's a topic that's very much in the news now. Roosevelt said that, well, you know, the justices are getting too old, right? We have all these justices over the age of 70. It's just not fair. And these old justices are not retiring even though they get a pension. So here's what we're going to do. For every justice over the age of 70, we will add a new seat to the court. And, okay, I can appoint them. So Roosevelt would have basically converted a 5-4 conservative court to a, I can't even do math that high. I think there have been 12 or 13 members, but it would have been basically all progressives supporting his agenda. Right? This plan was announced in March of 37, about a month before West Coast Hotel was decided. Now, as it turned out, Roosevelt's plan was very unpopular. Right? Even his own party opposed it. And they said that we can't pack the court. The number 9 is not fixed in the Constitution, but it'd be very unpopular to do it. We don't want to politicize the judiciary. But then West Coast Hotel came out. And by 5-4 vote, the court overrules Atkins. And who cast a swing vote? Of course, it was Justice Roberts. No relation to John. This was Owen Roberts. So for generations, the thinking was that Justice Owen Roberts changed his vote from before and now voted to reverse Atkins. And the thinking went, he did it in response to Roosevelt's plan. He was afraid. He was intimidated. For generations, law students learned of the so-called switch in time that saved 9. It's a play on this old saying, a stitch in time that saves 9. You know, if you sew your socks, right, you'll save the sock, right? If you mend a small hole now, you don't need to make a bigger hole later. So here it was a switch in time where Owen Roberts changed his vote that saved the 9 justices. Okay? It's not true. It's not true. Roberts had cast his vote back in 1936, before the plan was announced. Right? They cast their vote at a conference. We know how they vote at the conference. So he didn't change his vote because of Roosevelt's plan. Right? But people thought that anyway. And it created this myth of like, we can pressure justices by threatening to pack the court so they'll rule a certain way. Hello, see what happens on Wednesday, right? But we may be heading there very, very soon. Oh boy, it's gonna be fun. Wednesday might be a little bit dead, but I'll do my best. I'm doing ABC 13, their election night broadcast. Lord help me, it's gonna be a long night. Yeah, don't clap. It's gonna be painful. It's a public service. You're welcome. But the thinking was that this pressure on the court's actually successful. Now, for whatever reason, Roberts changed his vote. We can speculate. But the court definitely changed its approach to constitutional law after 1937. Right? 36 was like the high point. Like it was, Schechter, Poultry, and a few other cases. But 37 is when everything basically went the other way. And from 37 on, the court no longer reviewed skeptically federal and state legislation. Once you get to 37, things change. It's often called the Revolution of 1937. Right, the Constitutional Revolution of 37. After 37, Roosevelt would appoint a total of 9 justices. I mean, he had 8, but he made 1 Chief Justice. He made 9 appointments to the Supreme Court. He basically created in his image in every sense of the word. So whatever resistance exists in the 30s faded out after 37. West Coast Hotel was the sort of the breaking point where things went the other way. I'm sorry, Macy. I don't understand your question. Can you ask again? I'm not sure what your question is.
So when you were talking about the states enacting laws that directly conflicted with Adkins, isn't that what happened like last year when a bunch of states were enacting abortion legislation that directly conflicted with Roe?
Yeah, I think what some states have enacted were called trigger laws, which say that if Roe is overruled, this law goes into effect. I think that's how the laws work.
Gotcha. Okay, so not the same.
It's in a similar ballpark, though. There are states that push the boundaries of what the abortion laws prohibit, but I'm not aware of any state actively banning it altogether. It usually says if Roe's overruled, here's what will happen. They're called trigger laws. They exist in I forgot how many states, maybe about a dozen.
Gotcha. Okay, thank you.
Thank you. Okay. So, hold on. Quinn, who's next? Matt, you here? Matt? Nope. Jose, you here?
Yes, sir. Good morning.
Good morning. Thank you. Appreciate that. All right, Jose, you want to give me the facts? Or I think you already did the facts. You want to walk me through the court's analysis in West Coast Hotel?
Yeah. So basically, Justice Hughes said that wage laws don't violate the due process clause. That it has a presumption of constitutionality.
Ooh, hold on. You said a good word. What is a presumption of constitutionality?
So what I understand is that if the legislature enacts a law for a certain purpose, then the court must, respect the legislature's decision. Like if they're trying to do something, then it's probably constitutional.
Jose, let me ask you this question a different way. Why would a court review a law with a presumption of constitutionality? What's the basis of that decision?
I honestly, I don't know.
All right, let's try. Who's next? Spencer, you here?
Yes, sir.
Spencer, let me ask you this question, please. Why would a court establish a presumption of constitutionality? Why would a court review a law with a presumption of constitutionality?
So just saying you're frozen.
I'm sorry. I'm on my hotspot now, which is never a good idea. So, Spencer, the question one more time is, why would a court review a statute with the presumption of constitutionality?
Because they're saying the legislator, pretty much did their homework in enacting the law.
Is that what it's saying? That
consequences?
Do we always presume that legislatures did their homework? Is that a safe assumption?
No, not all the time.
But then why would a court defer to the legislature, even if we don't even know if the legislature did its homework? They just made this crap up.
I guess because the legislature is held accountable to the people.
Ah, okay. Why does it matter that the legislature is accountable to the people?
Because they speak for the people, and if the people of the United States don't agree with the laws that they're passing, then we can vote them out of office.
Ah, so you're saying the remedy to a bad law is the ballot box, not the courts.
Yes.
Imagine that. Law students hate this analysis, right? Or not always, I shouldn't say that. Some law students dislike in certain contexts. Because the thinking is, aren't the courts there to be sort of reinforcing the rights of the minority, right? Be counter-majoritarian. But what West Coast Hotel seems to suggest is that you apply a presumption of constitutionality, even if we can debate the wisdom of the policy. and we're not really sure of what the effects are going to be, the legislature is entitled to its judgment and needs to defer. This was a significant move, the presumption of constitutionality, because Lochner and the cases that came before it applied what you might call the presumption of liberty. That's what my colleague Randy Burnett calls them. And under the presumption of liberty, the burden belongs to the government. The government has to defend its law. But the presumption of constitutionality, the burden falls to the individual challenging it, right? Right? If you want to, the West Coast Hotel has to argue why the law is invalid. And the court is saying, you can try all you want, we're not going to listen. If this is a law in which people can debate, that's good enough for us. So West Coast Hotel flipped the approach to constitutional law. It didn't happen exactly in 1937, but it happened during this era, right? It happened during this era. During this era, in the 1930s, the court began to review laws with a presumption of constitutionality. Okay? But this presumption was not absolute. It was possible, in theory at least, to rebut the constitutionality. It was possible to rebut the presumption of constitutionality. It was possible for a litigant to go to court and say, no, deference is not warranted here because this law really makes no sense. And in theory, at least, a challenger could succeed in that role, right? He could rebut it. But generally, when you had a presumption of constitutionality, you were going to lose. You were going to lose. Okay? All right. There's a vigorous dissent from Justice Sutherland in West Coast Hotel. If you recall, Justice Sutherland wrote the majority in Atkins some years earlier. And he's kind of pissed because they just overruled his precedent, right? It's never good when you get your precedent overruled. So he's not happy about this. And he says that a deferential judge who automatically accepts the views of others has surrendered his deliberate judgment. So Sutherland is basically saying it's not our job to defer. It's our job to apply independent judgment. Who's better suited to make these decisions, the court or the elected representatives? Majority really doesn't engage this point because they disagree vigorously. Justice Sutherland also said that this is a sexist law, right? He had made this point earlier, that women stand on legal and political equality with men, and differences of sex afford no grounds to making the wage separate, right? Why are women subject to one wage and men to another? This argument didn't carry the day, right? People may have favored gender equality, but they perhaps also favored economic assistance in form of a minimum wage. So this argument wasn't too popular, but I know it always has at least some resonance when people read it, 60 years later, 70 years later. I guess almost 80 years later. Wow, we're almost 90 years later. Wow, time flies. All right. Questions in the West Coast Hotel majority, the West Coast Hotel dissent. And by the way, the live streaming is dead right now. I'll upload. I'm recording it locally. I'll upload it later. I'm on my hotspot and I can't stream both the Zoom and the YouTube at the same time. I'll kill it. So I have to triage. Okay. One just sort of historical note: the dissent in West Coast Hotel was joined by Justices Sutherland, Butler, McReynolds, and Van Devanter. Right? Sutherland, Butler, McReynolds, and Van Devanter. These were 4 conservative members of the court who voted together as a bloc. And they were known as the Four Horsemen, which was a play of the 4 horsemen of the apocalypse from the book of Revelation, right? Because they destroyed everything. Like when I see the Comcast trucks, like the horsemen of the apocalypse coming down the street because my internet's about to die, they were the 4 horsemen of the Supreme Court. This was really the last time that they all voted together, because over the next couple of years, they all either retired or stepped down. And then Roosevelt would make 9 appointments to the court. And the court would never be the same. He would completely revolutionize the court. So he didn't have to pack the court. We're living in an era now where court packing is very much in the air. Although don't dare call it court packing, call it court reform or some such thing. But there's a very good chance, depending what happens tomorrow. Oh my God, it's tomorrow. Depending what happens tomorrow, that we're looking at more than 9 justices, and it could happen in many different ways. I happen to think it's going to happen. I think it's a done deal. I don't think it's even close. I think it's going to happen, which will make my job much more difficult because we have 11 justices or 13 or 15 or 17 or 150 justices. I don't even know. It doesn't matter anymore, right? But I'll keep teaching what I'm going to teach. But the stigma about court packing stems from the situation where it was viewed that even Roosevelt had went too far. Then again, it was almost 90 years ago, and we're in a very different world. All right. Questions? All right. Let's move on to the next case. So the next case is a fun case, but not because of, its facts. Its facts were actually pretty boring, but facts that I very much like. And this is United States against Carolene products. So have any of you ever actually had Carolene products, Milnot? Everyone ever eaten it? Anyone? I have an entire case of it in my office at school, which I don't ever go to anymore. But I usually bring a can in to class. Condensed milk, right? It's a type of a dairy product that comes in a can. Now, usually, if you know, milk requires refrigeration, right? Refrigeration is expensive. But in the early 20th century, an alternate to filled milk an alternate to dairy was invented. It was possible to take milk from a cow and remove the dairy fat and replace it with vegetable oil. It might be coconut oil, right? Or some sort of vegetable oil. In other words, you could have this very sweet milk that would sit in a can, and it could stay ready on a shelf for months without refrigeration. And this product proved to be very, very, very popular because at the time refrigeration was expensive. As you might imagine, dairy farmers hated it because it provided competition. So what did the dairy farmers do? They tried to use the power of the government to shut down filled milk. And many states enacted bans on shipping filled milk. By the way, states also enacted regulations on margarine, oleomargarine, right? Why? Because it was a competitor of butter. You actually had some states, I'm not making this up, that required margarine had to be dyed pink, so you wouldn't confuse it with butter. Or to put some pink spread in your bread, right? Looks gross. So there were a lot of dairy laws that were used to protect farmers. Nothing's new. All right. But then Congress enacts a ban on shipping milk in interstate commerce. Right? You could not ship milk across state lines. And the government indicted and charged with a crime one of the companies, the Carolene Products Company, which was based in Illinois, for shipping an adulterated product interstate commerce. The owner of Carolene Products was a guy named Charles Hauser, and he challenged the constitutionality of the filled milk ban in his defense. And he argued that the filled milk ban was unconstitutional. Now, he wasn't going to win, right? There's no way, excuse me, there was no way he was going to win this case. No way. Why? Because you had West Coast Hotel the year before. And West Coast Hotel established the presumption of constitutionality. So this federal law we presume constitutional. Now, Hauser could attack it, explain why the law was irrational. But in this case, there was evidence in the record which showed that filled milk was not a good substitute for whole milk and injured the public, which is false. Right? Actually, the filled milk was actually healthier in many regards because it wasn't so fatty. But that wasn't very important back then. Okay? But that's not why Carolene Products is an important case, right? The facts just aren't that important. What really matters about Carolene Products was its footnote 4. Footnote 4 of Carolene Products is probably the most important footnote in the history of the Supreme Court. I'm probably not exaggerating, but I think it's probably up there. It's almost 500 words long, and it stretches 2 pages. Now, let me give you some advice. If you have a very important point to make, please don't make it in a footnote. It's terrible writing. Law students do this all the time. It's a bad idea. Your footnotes should not be that long. They should be short. Citations only. If you have a substantive argument, make it above the line. My general rule, which I deviate from very rarely, and only for very good cause, is if I have more than 1 or 2 sentences to write, it has to be above the line. I will not put it in a footnote. It's insulting to your reader to bury stuff important and stuff in a footnote. That's not a good practice. Put it up front. Don't hide it. But the court is not bound by usual rules, and they adopt this lengthy footnote. And I will have it on the screen over here in the class notes. I'll share it for a minute. Footnote 4 has 3 primary paragraphs. And the purpose of footnote 4 is to explain when the presumption of constitutionality does not apply. Right? Usually the presumption of constitutionality will apply, except here. So in other words, West Coast Hotel said we have this broad presumption of constitutionality, and then 1 year later we have Carolene Products, which says, here's where we're not going to apply the presumption of constitutionality. Right? If you want to think about the presumption of constitutionality as like a rational basis test, right? A very deferential standard review. Footnote 4 is your off-ramp, right? How do you escape rational basis review? How do you escape this deferential review? How do you go to what you might call heightened scrutiny, what we would call today strict scrutiny? That phrase didn't exist yet, but footnote 4 is your off-ramp from the usual rule of constitutional law. With Carolene Products, the court recognized that we're not going to be able to live with the presumption of constitutionality. There's certain laws that are just so bad that we can't possibly, with a straight face, uphold them. But, and here comes a big but, the court finds a line. And the line that Carolene Products draws is between the personal liberty cases and the economic liberty cases. It's not a straight line, it's not a crooked line, but the line's there. And the upshot of footnote 4 is that the economic liberty cases are stuck with rational basis review. And the personal liberty cases are on the off-ramp. They go to heightened scrutiny. Now, what are the double-dipping cases? Now, let's walk through the 3 paragraphs of footnote 4, and I put it on the screen for you all. Okay? So the first paragraph begins, there may be I cannot say this word, I'm sorry, a more narrower, I'm sorry, I can't say it. There may be a narrower scope for operation of the presumption of constitutionality. That's a fancy way of saying is the presumption of constitutionality may not apply in these situations, right? When legislation appears on its face to be within a specific prohibition of the Constitution, such as those of the first 10 amendments. Okay, what does that mean? If a law burdens the freedom of speech in the First Amendment, that law is not reviewed with a presumption of constitutionality. If a law violates the free exercise of religion, that law is not viewed with a presumption of constitutionality. If a law imposes unreasonable search and seizure in violation of the Fourth Amendment, that law is not reviewed with a presumption of constitutionality. Right? If there's a specific enumerated right in the Bill of Rights, a law that violates those rights are not reviewed deferentially. They can be reviewed stringently. Okay? Now think about this just for a minute. Is there a right of contract enumerated anywhere in the Constitution? And a right of economic liberty? The short answer is no, right? The Lochner Court was relying on the sort of notion of substantive due process that the 14th Amendment has these liberty interests. What the first paragraph of footnote 4 is saying is the court's not going to indulge in substantive due process anymore, right? We're not in the business of looking at what liberty means and making stuff up. We're only going to be looking at specifically expressly enumerated rights, right? The first paragraph is designed to kill off Lochner. It doesn't overrule. Lochner's never actually overruled. They don't have to, right? West Coast overruled Atkins well enough, but Lochner was never actually overruled. And the first paragraph accomplishes that very well. All right. Questions in the first paragraph, footnote 4. Let me stop the sharing. I can't see who's raising hands.
So it doesn't overrule Lochner, it just...
No one overruled. It's never expressly overruled.
So it doesn't overrule Lochner, it just Lochner?
It casts Lochner in a very bad light, right? It's difficult to reconcile Lochner with footnote 4, right? But it's never overruled expressly. All right. Any questions on the first part, footnote 4? Right. The key move here is saying we're not going to do substantive due process anymore. No more. No mas. Right. That's out. We're not going to do that anymore. All right. Questions? All right. The second paragraph of footnote 4 is a little bit different. Macy, I think Macy raised her hand, and Lainey, go ahead. I think Lainey was first.
When you said don't hide a substantive argument in a footnote, is that what the court was doing here? Were they hiding
yeah,
it?
Absolutely, yeah. Well, they weren't hiding it because it's you can't hide something when you have a Supreme Court opinion, but they were sort of. Let me give you some uncomfortable truths. Footnote 4 was a dicta. Look how it's phrased as, there may be a narrower scope. We don't have to decide this. We don't have to inquire. It was a dicta. This was not holding. And even worse than that, there are only 4 members who joined this opinion. So it was a dicta, not joined by the majority of the court. This is not an actual rule. And one thing that students often get hung up with is, you will not find in a Supreme Court case that says, well, this law is unconstitutional because of footnote 4. That's not how this works. Or courts will say is, well, in light of footnote 4, we're going to review this law a little more stringently. Right? That's how it's usually done. But this is not law. And people take it more seriously than it actually was. This was basically just it was a discussion of what could be without actually saying it. Justice Stone was a former dean of the Columbia Law School. He was like, law professor, Lord help us, right? We should not be in positions of power. Keep us far away from power. I'm serious. But when law professors are in positions of power, they say things that can be used in important ways. So he was just laying out some ideas. And he didn't know where it would go, but he was just sort of laying these things out. But it would prove very influential in the 20th century. Thank you, Lainey. Macy, was your hand up as well?
Yes, I just wanted to clarify that this footnote, this rule only applies to personal liberty cases, right?
It does a lot of things. I didn't get to the second paragraph yet.
Okay, I'll hold them.
Okay, very good. Thank you, Macy. Let's do the second paragraph. All right, so the first paragraph is suggesting that Lochner and substantive due process cases are no good. Now we get to the second paragraph, paragraph number 2. And it says, let me read it to you. It says, it is unnecessary to consider now. So again, it's a dicta saying, we don't have to decide this, right? We're not deciding it now. It is unnecessary to consider now whether the legislation which restricts those political processes which can ordinarily be expected to bring out repeal of undesirable legislation is to be subjected to more exacting scrutiny. What's going on here? We generally say that if there's an unpopular law, the remedy is the ballot box, right? Vote for different people who can repeal the law. But what if there are restrictions on the political process that make it harder to vote and make it harder to get bad laws repealed? The court says, well, maybe in those cases, the presumption of constitutionality is not appropriate. Laws that restrict the franchise should be reviewed stringently. So always someone says, Josh, especially election day, right? Does that mean, there's this right to vote and the courts can stop all these measures to make it hard to vote? No, this was basically a meaningless statement. Until the Congress enacted the Voting Rights Act in the 1960s, this was basically a dead letter. It didn't really mean anything. The courts were not super eager to declare voting laws unconstitutional. There were some, but these are sort of outliers. Okay? But the court's saying that, well, we can't have a presumption of constitutionality if you can't actually repeal in the legislative process a bad law. All right. Questions on the second paragraph? All right, let's look at the third paragraph. The third paragraph is one that I think is the most famous, right? People usually forget paragraphs 1 and 2, but the third paragraph I think is by far the most famous. Again, it's a dicta saying we don't need to inquire, right? We don't need to consider what happens when you have a statute that is ... And they list a couple different types of statutes. The first statute is directed at religious minorities. And they cite Pierce versus Society of Sisters. What's problematic about that citation? Pierce was not about religious minorities. The law also applied to a military academy. What the court's doing here is they're rewriting history. They're realizing that the double dip cases are good, Meyer and Pierce, right? The double dip cases are good. But they don't want them to be viewed as Lochner substantive due process cases. So Justice Stone, who's a very smart guy, says, well, you know what? Meyer was about free religion, and that's in the First Amendment. And the next question they say, Pierce was about religion. And the next question, they say national minorities, or national minorities, like in Meyer. Well, that's about German people who were a minority. That wasn't the holding of Meyer, though. Meyer was about the right of parents to direct the upbringing of their children. Meyer was about a teacher working in his job. So you see what they did there, right? They sort of laundered these locked-era precedents about personal liberty, the double dip cases that Bryce said earlier. And they recast them, they rewrote them as sort of First Amendment cases. Very subtle, right? Don't do this in a footnote. Don't rewrite Supreme Court precedent in a footnote very quietly. It's a bad idea. But yeah, when you're the king, you do whatever you want. And then they get to this next part that law students always focus on. And I think it's an issue that gets a lot of attention. They say, we don't need to decide if the presumption of constitutionality applies when a law is directed at racial minorities, whether prejudice against discrete and insular minorities may be a special condition which tends seriously to curtail the operation of those political processes ordinarily relied upon to protect minorities, and which may call for correspondingly more searching judicial inquiry. Okay, that's a mouthful. There's a lot going on there. Let's start at the end, right? At the end, it's easier to read. How are we reviewing laws? Do we use a more searching judicial inquiry? That's like strict scrutiny. Or are we using the presumption of constitutionality? Okay? Okay, what the court says is we don't use the presumption of constitutionality when a law curtails the political processes. Now that's very similar to the second paragraph, right? Because it says political processes in both paragraph 2 and paragraph 3. They're very similar. But the added focus in the third paragraph is not just laws that restrict the political process for everybody, but laws that restrict the political process for religious minorities, national minorities, or racial minorities. And there's a specific element. If prejudice against discrete and insular minorities are special, right? Even beyond racial, religious, and national, if there's prejudice against discrete and insular minorities, whether there's special conditions to trigger heightened scrutiny. Now, this phrase "discrete and insular minorities" is, it's an odd phrase. We don't really use language like that anymore. But the phrase "insular," think of like insulation, right? Like you have an insulated thermos, or you put insulation in your home. The phrase "insulated" means separate, right? Walled off, if you will, right? Like not part of the body politic. So if you're separating certain minorities, which can be based on race, but not necessarily, if you're separating minorities from the political process, the law does not warrant the sort of deferential scrutiny. Why? If people are unable to affect the political process, they can't vote bad politicians out, then the bad politicians will keep voting for policies that hurt the minority, right? It's sort of like a cycle, right? If you can't vote people out of office, they'll stay in office and keep you being unable to vote them out of office, right? So they will entrench their own power. This third paragraph formed an entire theory of constitutional law that focused on representation. And the thinking was that the courts would reinforce the representation of these sorts of minorities that are discrete and insular, right? So if certain groups aren't able to use the political process, the courts can intervene and help. Again, this is not actual law. It's basically a dicta, but it informed theories of constitutional law, right? You're not going to have a voting statute that says, oh, this law is unconstitutional, see footnote 4. That's not how it works. But this theory of enforcing representation proves to be very influential throughout much of the 20th century. All right, again, let me summarize. The 3 paragraphs of footnote 4 should be viewed as off-ramps from the presumption of constitutionality. Generally, the presumption of constitutionality attaches to a statute unless you touch one of these 3 bases, right? If you go paragraph 1, it's in the Bill of Rights. Paragraph 2, political process. Paragraph 3, certain types of minorities. If you hit these three, or one of these three footnote paragraphs, you escape West Coast Hotel. It's like the Hotel California. You can actually escape this one, right? You get out. It's a lovely place. It's a terrible place. I actually almost visited there once in Washington, but it was too far and I couldn't get there in time. But it's in Washington. If you can move into footnote 4, you can get out of the presumption of constitutionality. Right? So let me just give you just the sort of graphical interlude. If you have the video series, I encourage you to watch the videos here, but I have some screenshots for you. Right? The first stage is what we might call the rebuttable presumption of liberty. In cases like Lochner and Mueller and Buchanan and Atkins, the government had the burden to defend their law, to show that the law was reasonable. Right? This was a rebuttable presumption of liberty. But then we get to West Coast Hotel in 37. And in 37, you have the rebuttable presumption of constitutionality. Okay? This rebuttable presumption of constitutionality. And here, the burden is not on the government anymore. The burden is on the individual to show that the law is unreasonable. The third phase begins with with Carolene Products in 38. And Randy and I say that this case modified or qualified the presumption of constitutionality through footnote 4. And footnote 4, again, provided the situation where you don't apply the presumption of constitutionality. You can go back to a presumption of liberty, you might say. We'll get to the fourth phase, the Optical, in a few moments, our last case for today. But I want you all to see how this tracks. You start with the Lochner cases, with the presumption of liberty, with the burdens on the government, and then you get to the 1930s, you have West Coast Hotel. I didn't assign these first two cases. Your readings are long enough, but they're there also. Gorman and Nebbia. Where the individual has the burden to challenge it. And then you get to 38, which is Carolene Products, where the presumption of constitutionality still stands, but it's modified, qualified. Okay. Questions on West Coast Hotel and Carolene Products? Did I freeze?
You started to. I think it's okay.
Okay. I am sorry. I am on my hotspot, which is supposed to be 5G, and it's not always so 5G. I'm ready for backup. My plan C backup is I just call on the phone. That's my plan C if I can't get there on Zoom. But that's my plan C. Okay. So questions on Carolene Products. Very important case. I have a special attachment to this case. Yeah, right. I have a very special attachment to this case because I actually I blogged about it many years ago, and then one day I got an email out of the blue from a woman who said she was the granddaughter of the Carolene Products founder. I'm like, huh? Yeah, she was she was a relative, and she told me, my family had this this history of challenging the federal government, and Carolene Products actually had two Supreme Court cases. I'm like, two? So here's the family story, which I think is almost certainly not true, but it's a good story. The family story is after this case was decided, the company said, we need to challenge this law again. So Charles Hauser had this plan. He would drive a milk truck into West Virginia across state lines to deliberately get arrested to try and challenge the Phil Milk Act. His lawyer assured him, don't worry, you'll get arrested and make bail. But unfortunately, the judge was a bit of a hard ass, and he remanded him to custody. And the jailer, the marshal, was like, I'm not putting this guy in jail. So he had him as a dinner guest. That was the setup. But Charles Hauser went to the Supreme Court a second time, and he challenged the Phil Milk Act, and unsurprisingly, he lost. The most insane part of this is that after Hauser lost the second time, he petitioned for a pardon from President Roosevelt. And for reasons I don't know, Roosevelt gave him a pardon. This guy who sued his administration, challenged, made his life difficult, FDR gave him a pardon. And then Roosevelt died like a month later. This was one of his last official acts. So it's a remarkable twist of history. Unfortunately, Hauser's associates went to prison, but he got off. The funnier part is that Hauser was a staunch Republican who hated Roosevelt deeply, and he hung up the pardon in the men's room at their gentlemen's club. That's just how much respect they gave for him. I got all this from the granddaughter. Her name was Donna. Very, very nice person. But then the crazier part is, in the 1970s, a court actually declared the Phil Milk Act unconstitutional. There was a district court, I think in Illinois, that said this law is invalid. I had no idea. So after decades, Carolene products prevailed. I also spoke with one of the plant managers who worked for the Carolene Products factory, and they were so creative. They actually put this brass rail down the middle of the factory, down the state line, right? They built a factory on the state line, and they put a brass rail down the middle. So they would never literally move product from one side of the state to the other state. They would always keep product on separate sides. And they had cargo doors on both sides. So they would always ship it not interstate. Now, you and I all know that's not what Commerce Clause means, but they thought they were complying with the law. Sadly, that factory shut down about a year or two ago. I wanted to go visit. I never did, and I just never got to. It was in Oklahoma, kind of off the beaten path, but it was on my plans. Okay. Questions on Carolene. I have a case of Milnet at school. It's at school. I don't have it here, but I usually bring a can in for class. Colleen, who works in the library, she's the head of the library. She makes Milnut brownies with Carolene product Milnut. It was so sweet, I almost died. Oh my god, I felt like I was getting like a diabetic shock when I ate it. Oh my god, it was so sweet. But she likes them. It was too sweet for me. But it's really sweet. Anyway. All right. Questions on Carolene. All right. Let's do our last case now. We've done West Coast Hotel. We've done Carolene Products. Our final case then today is 1955, Williamson v. Optical. Now, by 1955, we are now almost 2 decades from the switch in time, right? We're 2 decades from the Roosevelt administration. At this point, almost all the justices are appointed by either Roosevelt or by President Truman. Actually, there might be 1 or 2 Eisenhower appointees at this point, but they're almost all progressives. And we get this unanimous decision in Williamson v. Optical. Okay? We're running short on time. I'll do the facts. These are glasses, right? We all wear them. Or I didn't used to wear them, now I wear them, right? If you want a copy of a pair of glasses made, there's a device called a lensometer, which you've seen this, right? Where they put the glass in this machine, they sort of spin the dials, they can figure out what your prescription is. And once they figure out what your prescription is, they can just make a new pair. They don't need to actually, inspect and give you an eye exam. In the 1950s, a company came around called Lee Optical, which is sort of like Lens Crafters, if you know the Lens Crafters. Like, it was a small glasses store that was not associated with, an eye doctor store, right? It was basically in a mall or a shopping center. That was a new business model. As always, when you have a new business model, businesses don't like competition. That's just the way businesses work. They try and shut competition down. So in this case, Oklahoma enacted a statute that prohibited these sorts of optician stores. They said if you want to fit glasses or make glasses, you need to have a doctor supervising it. And of course, doctors were more expensive. You couldn't have these sort of standalone shops that just sold glasses and made copies. Now, why did Louisiana, I keep saying Louisiana because of all the Louisiana cases. Why did Oklahoma enact this statute? Well, they had some rationales. They said, well, we want people to be inspected for eye diseases, right? If you just keep making copies of old glasses, you'll never go to an eye doctor. We want people to have inspections of their eyes. This is for health and safety. Was this law actually for health and safety? No way. No. Well, because you can go to an eye doctor and have them make a copy of your glasses without actually having an inspection, right? There was no requirement to have your eyes inspected. This was a law designed to help protect ophthalmologists and optometrists and punish the opticians. That's what this law was designed to do. Under West Coast Hotel, this law would survive the presumption of constitutionality. Probably. Maybe not, but probably would. This law does not trigger any of the escape ramps from Footnote 4. Right? There's no provision in the Bill of Rights at issue. This is not distorting the political process. Right? This is not about religious or discrete minorities. Under Carolene products, I think we're still stuck with the presumption of constitutionality. So Lee Optical was a fairly, mundane case. The district court in Lee Optical actually declared the statute unconstitutional. Randy loves that opinion. I'm not sure it's consistent with Footnote 4 and West Coast Hotel, but it happens, right? But it was easy enough for the Supreme Court to declare the statute valid. But why am I giving you this case if really it's not much new? Well, the court, in our minds at least, did something new. The court seemed to suggest that Footnote 4 and West Coast Hotel were too deferential. That the court should be even more deferential. And the court adopts a new standard, which says that the presumption of constitutionality is basically impossible to rebut. Basically impossible to rebut. At least West Coast Hotel entertained the possibility that you could rebut the presumption of constitutionality with evidence. Right? If you showed this law was really irrational. The government had no reason to do this. Then I think even under West Coast Hotel, you could win. But with Lee Optical, it went the other way. You couldn't win. You're basically boxing against a shadow. You're going to lose. Why? With Lee Optical, the test is not merely why did the government do what they do. It's a different standard. Right? The standard is, could the government have concluded that this is a reasonable law? Right? Maybe the government would have had a rationale for it. Even if the government didn't have that rationale, the court can make it up for them. Let me say that one more time. Usually you go to court, and the party has to defend their law. And they say, Your Honor, here's what we intended. This is why we did it. Here's a public interest we're trying to achieve. And that sort of justification, works under the presumption of constitutionality. But if we take seriously Justice Douglas and the Optical, they don't need to provide a defense. They can say, Your Honor, we enacted this law, the defense rests. Why'd you enact it? I don't know, you tell us. What do you think? Okay. And the court says, you know what, we think this would be a good law to help reduce diseases. Sure, why not? The key move with Lee Optical is it becomes impossible to actually rebut this presumption, right? Any law is going to be presumptively valid, whether or not there's a rationale for it. They may have intended the law was for public health. They may have concluded that eye exams are critical, right? It doesn't matter what they actually thought. It matters what they might have thought. If there's any conceivable basis on which to uphold the law will be upheld. Right? So again, West Coast Hotel and Carolene allowed you to sort of escape from the presumption of constitutionality in certain cases. You can either rebut the evidence or show there's a exception. But with Optical, the court sort of says, no. We're not even in the business. We're going to simply let the government win. When you have an economic right that doesn't fit within footnote 4, for an economic liberty, you're going to lose. The court will no longer strike down statutes that are out of harmony with a particular school of thought. Sounds familiar, doesn't it? Here, the court is adopting Justice Holmes. Yes, good old Ollie, right? Finally, when you get to the Optical, the court gives in to Justice Holmes. The West Coast Hotel approach, I would say, is more like Justice Harlan in Lochner, where you have a presumption of constitutionality, but you can rebut it with evidence. With the Optical decision, it goes full Holmes. Took almost 50 years from Lochner. Actually, exactly 50 years. It took 50 years from Lochner, but finally Holmes' opinion was vindicated. So the Lochner dissent, you had Peckham the majority, you had the dissent from Harlan, you had the dissent from Holmes. The Lochner dissent became basically the majority opinion in the Optical. Here, we're going back to Holmes. Maybe called Homecoming. I don't know. Homecoming? Whatever. I'm done. All right. Questions on this? Questions on the Optical? None? I don't believe you.
Just clarification. So this is the case that now, like, it from then on till now, that's how the...
I didn't say that. I didn't say that, did you? I never said that.
You said that current justices still use the Holmes approach, so I'm assuming that if this is the one that they adopted it as... So, am I jumping the gun on this?
You're jumping the gun a little bit, yeah. So this would be the law for about a decade or so, and then the court would have to deviate a little bit more. I know. Once we get to the cases involving what we might call birth control and abortion, they're going to have problems with this opinion, right? And let me give you a preview, if I can. Thanks, Tori. This case is saying we're not going to do substantive due process, right? We're not going to take a law that is based on some sort of nebulous liberty claim and declared invalid. Well, when they get to abortion and contraception, those are not in the Bill of Rights. Those are not limited to political process. Those are not designed to oppress religious minorities. So the abortion cases don't fit within footnote 4. So how do you squeeze the abortion cases into the Optical? And we'll get there in like a week. If I tell you now, it'll just be too confusing. So the short answer, Tori, is there are some cases where the Holmes opinion still applies, but it's not across the board.
Okay, thank you.
You're welcome. Oh, your flow charts are going to suck for your notes. I'm just warning you. I know you're going to try and draw them. They're just going to fall apart very quickly. Once we get to the 1960s, everything goes to hell in the 60s, literally, right? Okay. All right, let me briefly summarize. And this is, what I'm about to give you is on page 176 of your supplement. So I'm not giving anything new, but I think it's laid out pretty well in the supplement. I'll describe it for you all here. When we're talking about the court's approach to the due process clause, there really are 4 phases, 4 stages, if you will. The first stage was the Lochner era, the so-called Lochner cases, which was like Lochner and Buchanan and Atkins, where the court applies the rebuttable presumption of liberty, right? Where you presume that these sorts of regulations are invalid and the government has to defend its policy with evidence, right? This is this rebuttable presumption of liberty. In phase number 2, this was in the 1930s with West Coast Hotel, the court flips from a presumption of liberty to a rebuttable presumption of constitutionality, where you presume the laws are constitutional, and the challenger has the burden to show the law is unreasonable. This approach resembles Justice Harlan's Lochner dissent. So the Harlan opinion had a good run of maybe 10 or 15 years as the majority view. But this is all an exception with footnote 4 in Carolene Products, where there are specific circumstances where you do not apply the presumption of constitutionality. But still with footnote 4, the substantive due process cases cannot be justified. They sort of rewrite Meyer and Pierce as religious cases and minority cases, but that's not at all what they were. That's sophistry. It's false. But then we get to number 4, the fourth stage, with Lee Optical in 55. And here Justice Holmes comes home. The court applies a straight-up irrebuttable presumption of constitutionality that no evidence can rebut it. What it's basically saying is let the democratic process decide, not the courts. The courts are not in the business of deciding this. A reasonable person can think it's a proper measure, and that's enough. And here, the presumption of constitutionality is nearly impossible to rebut. Okay, questions? All right, I've started the minute poll. You can enter your answers as you wish, and I'll be back here around 12:30 for office hours. Thank you all so much.